All right, why don't we get started? And I have a lot to share at the top here, folks, so you'll be patient with my radio hosting skills here and see how well I get through this while folks continue to share where you're from, what you teach. We definitely want to know that. First of all, welcome on behalf of the presenting organizations here. First of all, the Sacramento Federal Judicial Library and Learning Center Foundation, also the American Bar Association Division for Public Education, and thank you, of course, to Catherine for her great work in setting this up. And also we want to thank a foundation that I have the honor of serving on the board of, and that's the James B. McClatchy Foundation, which has provided direct support for this. We're lucky to have Adam Liptak with us for today's conversation. Adam covers the United States Supreme Court and writes Sidebar, a column on legal developments. He is a graduate of Yale Law School. He practiced law for 14 years before joining the New York Times news staff in 2002. He was a finalist for the 2009 Pulitzer Prize in Explanatory Reporting, and he has taught courses on the Supreme Court and the First Amendment at several law schools, including Yale and the University of Chicago. My name is Joaquin Alvarez. I'm a founding partner at Studio To Be, which is a studio that supports journalists, both in terms of the work that they do, the content that they produce, but also the funding and sustainability for local journalism around the country in the United States. I have the honor of working with many local newsrooms. And of course, I'm a huge fan of yours, Adam. The overview for our series here and the work of the Federal Judicial Library and Learning Center Foundation. This is a three-part series. So this is the first of three. We'll be digging into more specific cases throughout the next couple of sessions, but today's first one is really a good one to start with. We're also partnering with the team at iCivics, and we'll talk a little bit more about that as we get into the conversation. Please, if you want more information, we can send you an email. We'll keep you updated by registering for this. We've got you in a queue, and we'll make sure that you know about these. And also, just so you understand the whole background on all of this, of course, there's a lot happening in our country right now, and it's so critical that we have these kinds of conversations to ensure that teachers, community members, journalists have not just the resources to do their work, but really the space for the kinds of conversations that we hope we're going to encourage and be able to generate here. So with all of that, Adam, welcome.
Thank you. It's a great pleasure to be with you and to be with all these good teachers.
Excellent, good. And just a little encouragement to the folks who are in attendance, please use the Q&A function. We will leave time at the end for dedicated questions and conversation and answers from Adam. But if you have ideas, thoughts, get it into the chat, get it into the Q&A, and I'll try to incorporate some of that as we go through our conversation. But we have a big case that recently got ruled on that, Adam, you've covered. It has pretty significant implications for free speech, especially in the context of schools with students and the reach of the First Amendment, the power of the First Amendment. And that's the Mahanoy, if I'm pronouncing that correct, versus BL case. Can you give us a little background on that? Give us some context for it and what actually happened that led up to the case.
Sure, I will do that. And I want to echo Joaquin's thoughts that let's make this as much of a conversation and a dialogue as we can. So don't hold your questions till the end. If I say something provocative or confusing or stupid, let's go ahead and jump in and press me on it. So this case involves a student, freshman at the time, Brandy Levy, in Mahanoy City, Pennsylvania, who was disappointed that she did not get onto the varsity cheerleading squad after having been on the JV squad, even though another freshman had been elevated. And on the weekend, on a Saturday, off campus, at a convenience store that teenagers like to hang out at in Mahanoy City, if you're ever there, go to the Cocoa Hut. She's at the Cocoa Hut with a friend, and they get the bright idea, they're 14 years old, that they're going to send Snapchat messages to about 250 friends. Snapchat messages are designed to disappear after 24 hours. And on these Snapchat messages, they notably put up their middle fingers and using the most versatile Anglo-Saxon swear word, they indicate their displeasure, the F word, by saying F school, F cheer, F softball, F everything, except they use the whole word. So that's some juvenile behavior. Although these messages are meant to disappear, they didn't disappear. Some other student took a picture off of one phone with another phone, and it makes its way to the coaches on the team. And the coaches, with the support of the school administration, think that this behavior warrants punishment. And Brandy Levy is suspended from cheerleading for a year. So she's disciplined by the school, although disciplined in the context of an extracurricular activity, not suspended from school or anything like that. Her parents are upset. They go to court and they win in the lower courts, in the appellate court. And maybe we'll talk a little bit about how broadly the appellate court ruled, more broadly than the Supreme Court was prepared to go. And it gets to the US Supreme Court. We have a very lively argument. This is a subject which I know from writing about it really engages readers, because it's not a complicated subject. You understand what the stakes are. People have strong views going both ways. But here the Supreme Court, by an 8-1 vote, says the Supreme Court, says the school board had gone overboard, had crossed the First Amendment line, and had violated Brandy Levy's First Amendment rights by disciplining her and awarded, in essence, awarded her nominal damages and attorney's fees. And although she's in college now, would have reinstated her to the cheerleading team.
Adam, I want to just double click on two quick things. So if I'm remembering the feature, well, there's one feature here which is not relevant legally, but I think it was the child of one of the coaches who actually captured it on
Yes,
Snapchat, right? Yeah,
that's right. So someone showed the thing to her mom.
right. And Snapchat is one social media platform. There are many at this point that young people or any consumer has access to. So it just happened in the case of Snapchat. That's one of the platforms where your message does get deleted at some point.
Yeah, so there's no suggestion in the decision. The decision leaves a lot of questions unanswered, but there's no suggestion in the decision that it would be different if it were Twitter or Instagram or Facebook.
Right. Well, Susan has a quick question. What year did the suspension take place?
I
think it was immediate, right?
2015.
Yeah. And so what the initial ruling when they win, right, which is broader, what was the key sort of feature of its broadness, like that it then ends up not being so broad when we get to the Supreme Court?
So one, you can approach this question in many ways, but if you wanted a clear, bright line rule, and there are advantages to clear, bright line rules, you might say, as the Court of Appeals here, the United States Court of Appeals for the Third Circuit in Philadelphia did, if it's off campus, it's none of the school's business. The school has power on campus sometimes to discipline students for their speech, but if it's off campus, you can't. And, as I say, that's an attractive rule in a way because it's easy to administer.
Yes.
But it's unattractive in other ways because there are things that happen off campus that have distinct on campus effects, like bullying, harassment, cheating, that most people would agree the school has to be able to address. So when it gets to the Supreme Court, they say, attractive though having a bright line would be, we're not going to tell you the answer to every single question. There will be situations in which public schools can discipline students for off-campus speech, and we'll give you some guidelines, some guideposts, but we're not going to answer every question.
And the guideposts that were provided, how clear are those? I'll give another example, made up, of course, for this context, but a student is bullying another student with the threat of potential violence. A school administrator or teacher sees it on social media. Does the court call out, like, that's okay for you to then go discipline the perpetrator of that bullying?
The court suggests, but doesn't say. It essentially leaves for another day the question, but it does in listing the kinds of things it thinks schools probably are allowed to do. It's that kind of off-campus speech with on-campus effects.
Right.
And bullying of one student of another that takes place off campus makes it hard for the bullied student to learn on campus. And I think the better reading of the Supreme Court is at a minimum to say that's possible. But I think you might go so far as to say they have no problem with discipline in that situation.
In the case that we're dealing with, we've got the Cocoa Hut. We have what some might view as a humorous, blowing off of steam, to quote Justice Kavanaugh, right?
Right.
I have children, they're older than teenagers now. This is common behavior. Does that somehow let the court off the hook of having to deal with the more complex issues where's the line on bullying, for example?
So this is in some ways the easier case, although it's not super easy for two reasons. One is that it's not crazy to think that this kind of criticism of an extracurricular activity that's built on team cohesion. I think the lawyer in the case says, I'm not sure I'd want Brandy Levy at the bottom of my pyramid.
Right.
That might give you a little more power to insist on people being part of the team. In a way, if it was speech about politics or religion, it might make it in that respect a harder case. But I take your basic point that this doesn't address the hardest questions.
We have a great question actually from Peter. We're just diving right in here, guys. From the Chicago suburbs, teaches high school con law. He asked, how hard would it have been for the court to use the Tinker standard, and we should give background on Tinker, to justify the school's punishment of Levy?
So let's talk about Tinker for a second, because Tinker really is the foundational case. It's old. It's from the Vietnam War era, and it's a pro-free speech decision. The great quote from it is that students don't shed their First Amendment rights at the schoolhouse door. And it asks the question of, can students wear black armbands to protest the Vietnam War, to silently protest the Vietnam War? And this is a case about on-campus speech. And even on campus, the court says you are not allowed, students have First Amendment rights, and so long as it doesn't cause substantial disruption to the educational process, you can speak wearing your black armbands. And that Tinker idea about substantial disruption was very much part of this case in the off-campus context. And much of the argument between the two sides was we should take this Tinker idea of, if it causes substantial disruption from off-campus to on-campus, then that should also be the kind of thing schools can act on. But in the end, that's not the direction the court went in. I hope that answered the question.
Yeah, I think it's really important for context too. I mean, another thing I would bring up, again, not to tease on the Cocoa Hut, but the stakes seem like they're of one kind in this case. In the case of Tinker, we were in a very, very complicated conflict. Thousands of Americans were yet to succumb in that conflict, and these young people were going even potentially of draft age soon. So the stakes seem different, but I guess one thing I'd love for your feedback on is just, you don't always know which case is going to end up in front of the court that's going to have this profound and lasting impact.
Well, the stakes are different and the nature of the speech is different. And one of the points, Justice Stephen Breyer, who wrote the majority opinion in the Mahanoy case, he makes three basic points, but one of them is schools have an obligation to teach about free speech and about the civics value of free speech and about the value of allowing people to say what they like as a general matter, particularly off campus, and particularly about politics. The First Amendment is centrally concerned with making sure citizens in a democracy can talk about politics. So the Tinker case, in some ways easier, some ways harder, but in this respect easier, that is clearly a political protest. Now, Justice Breyer is willing to cut Brandy Levy some slack and say that although juvenile, she was objecting to the process by which the cheerleading squad administered its selection process. Cheerleading squad at a public school, broadly speaking, part of the government. And so it's not wholly divorced from political speech. It's got a component of that.
There was a level of consensus with this ruling that seems like it might not occur so frequently with this particular court. Can you reflect on how we got to the vote? Arch of the ruling?
Yeah, so a lot of people have that impression that it's a unicorn to find a case that's almost unanimous. This was 8-1. Justice Thomas dissented. But in fact, the Supreme Court this last term, and it's not very far out of line with most terms, was unanimous 46% of the time. It's not so unusual. They try hard to achieve consensus. And this is a case where there's, first of all, most of the justices thought the school had overreacted, just as a practical matter. That was their intuition going in. Also, the court is a free speech court in general on both sides of the ideological spectrum, so it's not super surprising. And then Justice Thomas's dissent was in line with his earlier dissents. He just doesn't believe that children have First Amendment rights, period. But that dissent was an outlier.
And do you mind just giving us a thumbnail on what the nature of his dissent was, other than doesn't believe children have First Amendment rights?
He likes to go back in history and say what at the time of the adoption of the First Amendment, or at the time of the incorporation of free speech rights against the states in the 14th Amendment, what was the state of the law back then? And he found a case from Vermont, I'm making this up, but in 1860, in which a teacher had whipped a student for calling him old Mr. So-and-so, and the Vermont Supreme Court upheld that. And from that, Justice Thomas reasoned that we have some kind of baseline that allows discipline. And even Justice Alito, who's almost as conservative as Justice Thomas, had no use for that and said, we're not going to reply. Whatever flinty Vermonters back in the day might have thought, nobody today thinks public schools have the right to whip people. So that starts to undermine the general reasoning that we should look to history to give us the answer to these kinds of First Amendment questions.
Yeah, and I want to turn to the question of the technology, but Brandon had a quick follow-up here, which is, what do you think the court would say had the student called out the coach by name or directed profanity towards an adult staff member? Instead of F life, what if it was right. F the coach name?
I think that I don't know what the court would have done. And the fact that I don't know what the court would have done, notwithstanding that that's very close to these facts, tells you something about the case, that although it's a big victory for student free speech, it leaves a lot of questions unanswered. And I think it's entirely possible that going after a teacher by name with profanity, even off campus, might give rise to a different answer.
Well, let me ask one more question before we turn to the question of the technology in this case. But Morse versus Frederick, or as this is the Bong Hits for Jesus case, right? In Alaska.
The Bong Hits for Jesus case.
That's what I call it.
Who can resist?
Give us that. What was that case, and how does it intersect here?
That case was after Tinker, the court had 3 other cases, all ruling against student speech. The Bong Hits for Jesus case involved a school outing at which a kid had the bright idea that he was going to unfurl a banner bearing those words, Bong Hits for Jesus. And a great deal of the discussion in the case was whether that was a meaningful phrase or whether it was gibberish. And Chief Justice Roberts came to the conclusion that it was actually promoting drug use, and the importance of combating the use of illegal drugs by juveniles was sufficient to allow the school principal to discipline this student. Now, nobody disputed that this was under the school's jurisdiction. So it was, for our purposes, on-campus speech. This idea that we have special rules about drugs, that you can't comment about drugs, and that one can make sense of Bong Hits for Jesus, all of that is open to question.
And how did they refer to it, or was it referred to explicitly? I mean, if you were going to teach this in a high school class, this subject, and you've got this recent case, you go back to Tinker, but squeezed in the middle there is Bong Hits for Jesus. How would you sort of situate them? What boxes do you put them each in?
So we have this Tinker concept of disrupting school activities. And we have this Tinker concept that on campus is different from off campus. And this fits into both parts of those quadrants, right? It's I suppose it's undeniable that this will disrupt the field trip or whatever it was, and it's undeniable that it's on campus for jurisdictional purposes. But that was that to my mind is a closed case, whether you should be allowed to discipline a student for that.
I'm wondering, and it came up, and for folks who are, listening in on this session, there's a great daily episode that Adam did that kind of breaks this down. It's about 28 minutes, would be great in any curriculum. And advanced or elementary school kid would appreciate the podcast episode. But one of the things that came up was like whether or not these justices are familiar enough, or how important the question of familiarity with the technology itself is and will be, because one of the core questions here is, where is the internet, right? Yes. And especially in the last year where so many millions of students were at home, this question of jurisdiction and exactly what are the boundaries of the internet comes up. So how to think about that first, and then second, do we need a training course for justices so that they're up to speed, at least at a marginal level, to understand the dynamics of a particular platform?
Right. So on the daily, I suggested that they were out of their depth in dealing with technology. I don't think that prediction was borne out in particular in this decision, because I don't think the concepts were that complicated. The court seemed to be able to draw a line between that kind of speech on the internet, which was not directed at the school, was not on the school's email system, was not on the school's remote learning system, but really was meant to be, although it reaches the school, it was meant to be segregated from school activities. It wasn't directed at the school in a meaningful sense. Or let me put it to you this way. It's not very different from, let's say that Brandy Levy was having a slumber party. And with a dozen other students, they were sitting around at midnight and they were saying mean things about a teacher. And that made its way back to the school. You would think those are two different realms, the slumber party and the school. The internet, of course, is ubiquitous, but you can still draw some distinctions. But is it the school's computer? Is it the school's email system? Is it the school's remote learning system? Was this sent to the school, aimed at the school in some fashion? Or was it, as best as you can, segregated? And in this respect, Snapchat is a little more segregated than, say, Facebook is.
Yeah, but I mean, what if? What if in that same series of posts, or that one post, they had said, I'm going to go take a bong hit to relax? Would that have crossed over and been covered by the other ruling?
I think not. So we've talked about the guidepost that Justice Breyer gave us. He gave us three. One of them was that there's an obligation to teach people about the First Amendment, including by how you discipline students. But a second concept, Justice Breyer said, was very important, was in loco parentis. Is this the kind of thing that's the responsibility of the school, or is it the kind of thing that's the responsibility of the parent? And while you're on campus, the school has in loco parentis authority over the student. But while you're at home, that primary responsibility ought to belong to the parent. And the parent may well want to take steps right away if a student announces that he or she is about to take a bong hit. But, and this will take us to the third guidepost that Breyer says, we don't want a situation in which the school, like Big Brother, is monitoring students 24/7, because that's for parents to try to do.
Okay, good. And we've got two more questions. Greg coming in with a good one. Do you know if the court considered the Bethel v. Fraser criteria of lewd, obscene speech being under the auspices of school power to discipline?
So they mentioned Bethel only in passing.
We give people a little thumbnail on.
Just to remind people.
Yeah.
So Bethel was a kid at a school assembly or graduation or something who used elaborate sexual metaphors in his speech, undeniable juvenile puerile ones. I mean, maybe some people would find them funny, and was disciplined. And there, the difference is, again, is it the Tinker framework really works well. Is it on campus, and is it disruptive of the school activity? And there, answer, certainly yes. In Brandy Levy's situation, most people would say it's off campus. And then you can argue a little bit about disruptive, but not particularly disruptive.
Yeah, thank you for that, Greg. And finally, Susan, how will this affect student codes of conduct?
I think the court left open, and particularly in the context of extracurricular activities, that what you can't achieve just by brute force, you might be able to achieve by a kind of contract with the students. It's much easier in the extracurricular activity setting, where even the lawyer for the ACLU, David Cole, representing Brandy Levy and her parents, said, listen, if at the start of the season, you had people sign a promise that you're not going to disparage the team, you're not going to drink off campus, you're not going to use swear words off campus, you're going to hold yourself up to certain standards as a condition of not the core educational function, but the extracurricular activity, he said that may well be okay. Now, a general code of conduct that is a condition for getting your education at all, much harder.
With this, I mean, is there a danger, though, that you end up with like these binding arbitration clauses in all consumer agreements where students will have to sign away, right? Their ability to even find the corner where free speech is possible if schools start wanting to sort of affect their codes of conduct to cover everything. Because couldn't you ask, hypothetically, couldn't you ask a student coming on campus, sign this agreement that you're not going to do any of these things on any platform in perpetuity while you're a student here?
Right. And so to go back to my earlier answer, I think that that general idea that this is a condition of being a public school student at all probably doesn't fly. I mean, there are certainly doctrines in the law that are called unconstitutional conditions that you can't sign away your First Amendment rights. Extracurricular activities, as I say, are different. And I think another thing that runs through this decision, not so much in its reasoning, but in its tone, is people. Let's use a little common sense here. Let's use a little judgment and discretion, and let's let kids be kids, and let's not be unduly intrusive on, juvenile nonsense.
I'm always struck by the remarkable history of people from all corners of the country ending up with their cases in front of the Supreme Court. So I don't know how much you know about all these folks, but what happened to this young student? Is she still in high school? What happened to Tinker? Right, the sister is still going on this topic, and then also the case of Alaska with Morrison Frederick. What happens to somebody when they win or lose at the Supreme Court?
I think what happens is that they're invited to a conference every year or two on the 50th anniversary of Tinker. And it may be something you tell your friends and they look at you quizzically about, really, you were in a Supreme Court case? But my sense is it doesn't fundamentally alter the trajectory of your life, usually.
And Ms. Levy, is she a high school graduate at this point, or is she still in the school?
She's a college student. I think I read that she's studying accounting. I'm not sure where she is.
Yeah. So I would like you to just, again, you're not original reporting on this because it's a little speculative, but again, I just want to double click one more time on this idea of the number of places that free speech is happening right now, and how complex the technology is and how to keep the guideposts there. If you're teaching this subject, and we have 50 teachers signed up for this conversation, how would you start the conversation in a classroom with high school students?
So I might start by making two fundamental points. One, that the United States is distinctively committed to free speech values in ways that would baffle the rest of the world. The hate speech we allow, the protections we give to the press are essentially unknown in the rest of the world. And on the whole, and maybe not so much recently, but on the whole, it's served us very well. The other is that a public school is part of the government, and the First Amendment constrains the government, and that a public school also should have some obligation, not only to make sure that students have a valuable educational experience, but also that they have exposure to the values that have made our nation great. And among those values is free speech. And one way to teach those free speech values is to tolerate speech, even though it might be offensive to some.
If we have, and Susan's pointing this out, her school makes students sign a code of conduct that says students can be disciplined for negative comments on social media about a school organization. Who arbitrates that? And is that technically even legal given what the Supreme Court just ruled on this case?
So the going in proposition is it's hard to fight City Hall, that if the school thinks it can enforce that, it probably can enforce it unless you have parents like Brandy Levy's parents who are prepared to go to court. And not many parents are, and I'm not sure that's the best use of time and resources. But I would question, it's not at all clear to me that that kind of policy is defensible in court. And I go back to what I was saying a second ago, where I think the school district should ask itself whether it shouldn't tolerate and maybe even encourage criticism of school organizations, school processes, as a didactic matter, as a way to demonstrate to students that free speech, in the sense of clashing opinions and values, has a place in our society, in our schools, in our educational systems.
Given the comment, I think Justice Breyer wrote "Nurseries of Democracy," that this is a platform where we are educating and preparing students to be active members of that democracy. And January 6th, the state of politics, the rise of misinformation, both domestic and international. Are they really the nurseries of democracy? Are we missing some is it working?
Yes. So my background is I used to be a First Amendment lawyer. I used to be a press lawyer, and I, for the longest time, had an unquestioning belief that more speech is better, that people can be trusted to use their critical faculties to make sense of what they're hearing, that the truth will emerge from a contest in the marketplace of ideas. And I have to say that for some of the reasons you just listed, even my faith, which is pretty, drink the Kool-Aid kind of faith, has been tested some. So we may be in a situation where we're rethinking some of these fundamental ideas about the American commitment to free speech. And all of this is amplified and made toxic in no small measure by social media, and by the way people are siloed in their information, and by the way we don't have a common set of facts.
There's been some talk, and we'll do a little sidebar here, no pun intended, but the Sullivan ruling that is so important for journalism and protecting journalists. Yes. Justice Thomas and I think Gorsuch have both raised the specter that, well, maybe that needs to be reconsidered somewhere down the line. Can you give folks a little background on that and just what's the trajectory? Is there some case that could overturn it?
It wouldn't be hard to come up with a case in which Sullivan was reconsidered. Sullivan, of course, was the case in which the court, in order to protect the civil rights movement, said that public officials, government officials, who wanted to sue the press or others for libel, had to overcome a very daunting hurdle. They had to prove actual malice, which is to say, they had to prove not only that something false was said about them, that something defamatory was said about them in the sense of lowering reputation, but also that this false and defamatory thing was said by someone who knew it to be false or who acted with reckless disregard, another legal term of art, meaning entertained subjective doubts about its truth or falsity. So it requires you to get into the head of the person who wrote the thing and essentially prove that they consciously lied. That, of course, gave the press enormous protection, makes it very hard for government officials to sue the press. The court later expanded it not only to public officials, but to public figures, to celebrities, to people caught up in current events. And the recent dissent by Justices Thomas and Gorsuch suggested that that last step, it's one thing to be criticizing the government. Political speech criticizing the government is the core of what the First Amendment protects. The stuff about celebrities and people caught up in public events, maybe that ought to be revisited, they said. I don't think that's wholly crazy. I think it's pretty hard to locate these concepts in the text or historical understanding or structure of the First Amendment. But at the same time, as a member of the press, it's a little terrifying to think we have two votes to take a fresh look at what is really one of those precedents. I mean, I think there may be half dozen that almost everyone has heard of.
If you are in the chat or in the Q&A and you teach, this in your classrooms, any version of this, I would love to know if anybody teaches Sullivan to high school students. I do a lot of work with community colleges and their journalism programs. And in some communities in California, again, as wealthy as most nations, if not most nations, the state of California has news deserts all over, up and down the Central Valley, in the far north, in major cities. I'm from Oakland. The Oakland Tribune was shut down by the hedge fund that took over ownership of it. I'm now on another nonprofit board that has a newsroom reestablished there called Oakland Side. But in a lot of communities, it's fragile. And people's relationship to local journalism is also fragile. And so what kind of, I mean, you're at the New York Times. This is one of the great institutions of journalism, but it has more resources than most. So if Sullivan were to get disrupted or halved or diminished, do you fear for the ability of smaller, less wealthy, less powerful news organizations to do the work?
I think that's a legitimate question. Of course, the greater the risk that you're going to suffer a crippling libel judgment, or even have to defend, because you pay your own legal fees even when you win, even to defend a serious libel suit is no small thing. Libel insurance does exist and is available, but if there were more libel suits, the cost of libel insurance would go up. So the Sullivan case has played a powerful role, and not always in an obvious way, in protecting the press. One way it protects the press is it makes it less attractive for people to sue, not only because they're likely to lose, but because the ground of the dispute is not about truth or falsity. If I feel like something false and defamatory has been said about me and I want to set the record straight, and if I could go into court and the court could establish whether I was right or I was wrong, which is essentially what we have in England, that might make it more attractive to sue. In fact, you might be compelled to sue. But if the dispute is going to be over, did the guy who wrote it, did the woman who wrote it believe what he or she said? That's not such an interesting question. So that also discourages libel suits.
I wanted to go a little bit further into this so we can spend some time talking about civics education, honestly, and how it's happening, where it's happening. We've got a great partner in this work at iCivics, which has a great history and has been super innovative. But honestly, I mean, when I was in ninth grade, it was a required course in California to take civics. My children went through public schools in California and did not have to take civics. It wasn't even offered. So any perspective on how we're doing in terms of civics education in this country? And if you see some bright spots, where are they? And if also for our attendees, if you've got great examples, please put links into the chat.
So I'm a particular I have a particular soft spot for iCivics because of Justice Sandra Day O'Connor's great involvement with it. And I think civics education is indeed lacking. I think iCivics does a good job in trying to make it lively and accessible, but it's not easy. It's by its nature, at least when you talk about it in the abstract, a little dull, and it doesn't seem to have an impact on students' daily lives. So the challenge in teaching it is to find real world examples about places civics can make a difference. And that's one of the reasons this Mahanoy case, not directly about civics, but nonetheless is such a great teaching tool, because every student will have strong opinions about what the right answer was and maybe even about where to draw the lines.
Do you think that there is a question? I mean, there's a lot of discussion around dealing with big tech and Section 230 reform, right? And for folks who are don't know this background, it basically limits liability for online platforms in terms of what appears on there. But if there's Section 230 reform, is there a possibility here that we could end up limiting First Amendment rights by requiring more stringent editing or censorship by the tech platforms?
So Section 230 is a complicated thing, and I think it gets shorthanded and misunderstood in a lot of ways. Section 230 does give tech platforms enormous immunity, but withdrawing that immunity, it's not really clear where that leads. But just to talk about the difference between a print publication like the New York Times and a tech platform like Facebook, if we publish a letter to the editor, it is as though we said it. We're on the hook for it. We selected it, we curated it, we moderated it, we edited it, and we can be sued for it, even if we don't agree with what it said. If Facebook publishes a post under Section 230, it has immunity. And if someone comments online on a New York Times story, we also have Section 230 immunity. So that's kind of a weird situation where the enormously powerful tech platform is treated more leniently than the struggling newspaper. However, if you take away this immunity and say that the tech platform is on the hook for everything it posts, the inevitable answer will be it's going to post less. It's not going to want to be subject to suit over what it puts up. So this notion that somehow withdrawing Section 230 immunity will lead to more speech seems to me backwards.
I want to just go back to the Q&A here really quick, because Peter is way back in here and asked, this case didn't seem to be one where the court was going to give a Tinker-esque ruling, but they took the case anyway. That said, under what conditions could you imagine that this particular court would issue a bright line ruling on free speech in schools?
I think the lesson this court took from this case, and an oral argument, two different justices said, in essence, this is too complicated. We can't write a First Amendment treatise here. This has to be situational, discretionary. People should use judgment. I think, in a sense, the court was trying to tell the schools, the public schools of the country, use some common sense. This is not the kind of area where we can give you an on-off switch about where discipline is permissible or not, but we want to encourage you to use a light touch, to allow speech rather than forbid it, particularly if the disruption on campus is small. We're not talking about bullying, we're not talking about harassment, we're not talking about cheating, we're talking about a tantrum. And you know, I think that tone, that message, might have sent this court, if it had the Bong Hits for Jesus case in front of it, in a different direction. You know, that kid was silly. That kid was out of line. Does that kid deserve to be suspended from school? Not clear.
Yeah. And Greg, a long comment. I'm going to try to sort of adjunct it here a bit, but in speaking to the frailty of the freedoms afforded to the press to express ideas contrary to positions of power, this case has a dark undertone regarding schools being powerless in the expanding cyber world. It feels like the court disregarded a prior case that upheld the school's ability to hold participants in extracurricular activities to a higher standard. Palmer v. Merluzzi case, the school was ruled to be correct in suspending the football player. Participation was ruled as a privilege, not as a right, and therefore codes of conduct can be higher for those more in the limelight of the school. This ruling makes this issue much less clear. Although the ACLU lawyer did call it out. I mean, they even acknowledged you could have those codes of conduct.
Yeah, and there was a code of conduct here. The appeals court said it didn't cover this activity. The Supreme Court didn't speak to that. And so I'm not sure that there's a complete disconnect between the Palmer case and this case. And I think that schools that really care about this kind of stuff in the extracurricular context, but only in that context, not to say that that's not important, that's a big part of the educational experience, athletics and so on. I think making extracurricular activities conditioned on giving up some substantial amount of free speech rights is probably permissible. Don't know if it's wise, but it's permissible.
Well, I want to go to the policing of these things. I mean, if the court had ruled in favor of the school district here, right, and suddenly speech at the Cocoa Hut is regulated or is under the governance of the school, how do schools keep track of it? I mean, then do they have to monitor all Cocoa Huts in Pennsylvania?
Right. So that's a great point, and that was one of Justice Breyer's 3 points, that we don't want to be in a world where the school district is the NSA and is monitoring and big brothering and sucking up every communication that every high school kid, day or night, away from campus, in another state, whatever, is putting on the web. So that's really a disturbing situation. And nor does it seem to be particularly attractive to rely on the happenstance about whether some kid shows something to her mother. So for all those reasons, you want to let not only all human beings have a zone of privacy and autonomy, but also teenagers deserve some of that too.
I want to kind of pull on the thread a little bit more relative to that autonomy and this nurseries for democracy. But there's an open question around the role of the rule of law in the United States of America right now. There are some that would argue we have state legislators trying to fork it or take it back 100 years. Are we doing a disservice to the high school student, the middle school student who is being introduced, is being immersed in hopefully the right training to be a member of this democracy? It seems like there's some bigger struggles out there. So I just would, again, like you to kind of come back around. I don't know if you see this at the New York Times. How do we tell this story in a way that doesn't further people's suspicion that the rule of law maybe is not so strong anymore in the United States of America?
So I guess I'm not completely following how that real problem maps on to this particular case. I mean, I think in this particular case, I might have predicted that the court would say the appeals court went too far. This notion that schools can never discipline off-campus speech is wrong, and we'll send it back down to the lower court for them to rule on whether this was the kind of disruption that actually warranted discipline. The fact that the court not only did the first thing, and it did that, it said the Third Circuit was wrong, but it said, but we're going to decide, and we're going to decide that this kind of speech is permissible, this kind of speech ought not be disciplined. I think is a small victory for the rule of law, and it demonstrates that the court cares about the First Amendment, even in what may seem to some an idiosyncratic case. You can criticize the court for not laying out a lot more detail about what to do in other cases, but I don't think this was a bad moment for the rule of law.
No, I totally concur, and I'll try to come back on my mapping exercise, which might be a little complicated. But I'd love to get your thoughts on other things that have happened at the court during this term, particularly on voting rights. But what else has been called out? What have you been covering for the Times?
So it was a very active term. It was the first term, of course, with Justice Amy Coney Barrett, the third Trump appointee. It was the first term after years and years in which the court was essentially a 5-4 court with a swing justice in the middle. For many years, Justice Kennedy, more recently, Chief Justice Roberts. Now we have a 6-3 majority, and what we were looking for is how much was that 6-3 majority going to steamroll the 6 Republican appointees, the 3 Democratic ones. And you got somewhat mixed messages there until the last day of the term. In the most important case of the term, the court looked at what remains of the Voting Rights Act after the court had torn the heart out of it already in 2013. And the court, by that majority, quite distinctly rolled back the remaining protections in the Voting Rights Act at the very moment that Republican-led state legislatures around the country are imposing voting restrictions. The court made it much, much harder to challenge those voting restrictions on the ground that they violated the Voting Rights Act, the civil rights landmark that means to protect minority voters. So that decision cast a shadow over the rest of the term, which was more complicated and had cases like the one we've been discussing, had a unanimous decision in favor of student athletes against the NCAA, had a 7-2 decision upholding for the third time the Affordable Care Act, had a unanimous decision, at least as to the bottom line, in favor of religion and against gay rights in the context of foster care. So it was a term that had many strands to it, but I think what people will remember of it, given the moment that we're in, and given the stark divisions and given the consequences, is the voting rights case on the last day of the term.
Yeah, and adjacent, we have an anonymous attendee regarding civics education. I'm in Texas, and due to the recently passed legislation as a teacher, I as a teacher feel hobbled in terms of what I can teach regarding civics. Parents have no problem pursuing lawsuits and threatening teachers' jobs. What are you seeing from your reporting vantage point of that kind of pressure at the ground level?
Yeah, so I wish I did more ground level reporting, and I only know what I read. And at first I was surprised that we have an anonymous comment. And then when I heard the comment, I was saddened, but understood why we might have an anonymous comment. And we are also living in a world where even exposing students to various kinds of ideas and letting them exercise their critical faculties in making sense for themselves about what some people call critical race theory, or whether you can have a candid look at the history of the Alamo. All of that seems to be under assault now. And needless to say, that can only sadden me and the likes of us.
Yeah, and if I could go back to my mapping exercise, I have high school nieces in Arizona who live in Maricopa County, who are standing by while we're excited to be ready to vote and drive and go to college. They're watching cyber ninjas do whatever they're doing with the vote recount. So that's that layer. But I do think on the question, just let me ask it as a non-legal person, does it not violate the rights, the free speech rights? If you're a student in a class and ask a question about critical race theory or the Alamo, can you prohibit a teacher from giving a straight answer?
That's a complicated question, but most cases suggest that schools have a substantial amount of authority in deciding what the curriculum is and isn't. So and that a government employee, unlike a student even, loses some of his or her First Amendment rights as when they're working in their governmental capacity. So while I would love the answer to be, you can say what you like, it's more complicated than that.
But could a governor in a state that is suspicious of the vaccine for COVID-19 instruct public health officials to not talk about it?
I'm afraid the answer to that is yes.
And we shouldn't be surprised if maybe that happens in some cases.
I don't know. I'm not going to go down this road much further.
Yeah.
But the government can speak. There's a doctrine known as government speech, and it can take positions on things, and those positions can be controversial and even wrong. But the citizenry doesn't have a First Amendment right to compel the government to say one thing or the other.
Yeah, thank you, Adam, for letting me geek out on that a little bit. And we've got Elizabeth. Most legislators here in Arizona couldn't define critical race theory, CRT, if they wanted to. It's frustrating as a public school teacher here to consistently be legislated against. So again, I think maybe one, this is not a silver lining, I wouldn't project it as that, but one opportunity with this particular case, right, is to point out where the process maybe does work in a way that is pretty clear. On some of the other cases also, which I want to just ask you about, on the NCAA athletes getting paid, were you surprised by that? Just any color commentary on that ruling?
Well, that case, like the Mahanoy case, is an opportunity for the court to come together, in that case unanimously, on something that just strikes most people as unfair. You know, it's crazy the amounts of money the NCAA makes, that coaches make, that the assistant weightlifting coach makes. And meanwhile, the kids who are jeopardizing their health and futures get essentially nothing. I mean, there's just almost nobody thinks that's a great idea. Is there a value of amateurism? maybe. The only question in the case was a quite modest one of, can you give student athletes education-related benefits like graduate school scholarships and internships and musical instruments and computers and so on. And I think the court had no problem with it and was happy to be able to be one of those 46% of decisions in which they came together unanimously. It left open the much harder question of, can you pay them salaries outright? But at least in Justice Kavanaugh, himself a coach, in a concurring opinion, said, why is this the one area in American life where we let a monopolist in a labor market say, we would like to pay our labor nothing? Could all the law firms get together and say, we'd like to pay our associates nothing? And then when you put it that way, it makes you think the court will be receptive to the next round of challenges too.
This strikes me as another incredible opportunity for teaching. I'm sure teachers are using it, given the presence of high school sports, all over the country. So Jason, as a follow-up, with the Mahanoy, I don't know how to pronounce this case, really have been any different if she had been issued a school computer and used it to make her comments? And in the background here, during the pandemic, it was already happening, but many districts went one-to-one and just issued Chromebooks or iPads or whatever to students. What if she had used school equipment for that?
The ACLU, defending Brandy Levy, says that's different. That is as though it happened on school grounds. And it's a very good question because it gives you a sense of how artificial some of these distinctions are. I mean, I'm talking to you on a New York Times computer, but I'm not doing New York Times activity. And, these lines can have to blur.
Elizabeth makes the point, she really does appreciate your reporting on the Daily podcast, and she utilizes it often in her AP class. How many teachers reach out to you, Adam? Like, do you talk to teachers a lot?
I get communications, yeah.
And do you do guest speaking? I'm not asking you on behalf of anyone, but how do you spend time in classrooms? I mean, you teach at the university level, of course.
Within reason and in the off season, yeah.
Yeah.
You can't. I mean, one thing that happens to me fairly often is I get a note from a student. I'm a sophomore at such and such place in Evanston, Illinois, and I'm supposed to do a paper and interview somebody about the First Amendment. I say, happy to do it. And I, spend 20 minutes with the student. And then all of a sudden, the next day, 3 other students from that same place pop up. But there's a first mover advantage. One school, one student, can't do everybody.
Yeah, I want to go back to iCivics for a second because it is an extraordinary, initiative. And I got to sit in 2 meetings in the very early days when it was called Our Courts. The Justice O'Connor and her leadership on that was extraordinary. And she's singular in so many ways. But do you see today's justices being really directly engaged in this question of how to encourage that nursery effect, that training ground? Like, do they spend their time giving speeches? Like, how active are they on this issue of civics in education?
They're pretty good. And they also sometimes appear in combinations that you wouldn't expect. So I saw a civics speech by Justice Gorsuch, fairly conservative, together with Justice Sotomayor, fairly liberal, and they do care. Again, it's important and it's hard. I mean, if you're 15 years old, this is maybe not what you're naturally inclined to spend your time thinking about.
Yeah, and just any thoughts on this idea of studying the expansion of the court, let's make it 15?
Oh, I think the more you can tie it into current events and current controversies, January 6th, court expansion, term limits or mandatory retirement ages for the justices. When you start thinking about that, and it's also, I find one good way, at least for me, but I think for students maybe also, is not only to say, here's how the US system works, but do a little comparative work. What do other developed democracies do? It's different. Is ours better or worse? Ours is not necessarily better. The Electoral College, open the question. The Senate having 2 senators for each state, large or small, open the question. The filibuster, open the question. So I think if you can get away from abstractions and drill down on the hot topics of the day, that might make it more attractive.
Yeah, and let's leave time for 3 or 4 more minutes of questions if anybody has them. This is our last speed round here. I want to ask you just a question about being a reporter at the New York Times, of course, not what's your job like, but how do you manage the fact that you've got the daily, you've got the site, you've got social media, you have to write articles. Where do you start? Do you start in the writing, or like what's your process like?
Well, getting on a big news day, there's nothing more important than getting something up on the web first. That's my first job, and I have to do it awfully fast. And sometimes multiple big decisions land simultaneously. And those, I got to tell you, are very hard days. And then I will make time for the daily and other things like that in the middle of the day and the afternoon. And then there's another burst of energy writing for the next day's paper. I don't know how many people still even see print newspapers, but that's still part of our legacy. And the story that eventually, the third or fourth draft of my story that eventually gets published in the paper, the archival version, gets a great deal of my time too.
Yeah, well, it's extraordinary, and you produce so much, which I'm a huge fan of it. And again, would encourage everybody to tap all of those as resources. Greg's coming in with a 2-out single in the 9th inning here. Just in general, do you foresee any concerns for granting I'm assuming certification with the 6-3 court split? Will a liberal rule of 4 be likely?
So I think the reference is, most things at the court, which has 9 justices, take 5 votes. But in order to add a case to the court's docket, to grant certiorari, using the legal Latin, only takes 4 votes. And for the longest time, the court has been taking fewer and fewer cases. And maybe as a function of, you didn't know whether in voting to grant cert, whether you're going to pick up the 5th vote of Justice Kennedy or Chief Justice Roberts. Now with the 6-3 majority, the 6 justices, any 4 of them in putting a case on the docket has a pretty good idea of where it's going to come out. So that will likely both increase the number of cases the court hears and also move the court a little more rapidly to the right.
Okay, thank you for that. I'm going to 2 more minutes. I got one easy question, and they'll just, if anyone's got any last ones, final call here. What's the best television show, scripted, made up, fictional, on the law that you've ever seen? What's your favorite?
Well, I'm not even sure I have an answer to that.
What?
There were some old shows I used to like, but this is for anyone, over 40, these will probably be meaningless. LA Law and Murder One, I like those shows, but I can't say, the recent HBO series, Perry Mason, was pretty good, but I'm the wrong person to ask.
So good. We'll take those answers. No, we'll definitely we're going to certify those answers here. Okay, I'm not seeing any more action here in the chat or the Q&A. First of all, I want to thank you, Adam. This has been a real joy for me, honestly. I'm such a huge fan. Pleasure. Yeah, thank you. And thank you to everybody who's been participating in the chat. You guys have been great. Thank you for doing what you're doing. Thank you for sharing. I hope people are catching those resources and sharing them out. Join us again. So we got 2 more of these in the series. And I'll thank again, Catherine, everybody at the American Bar Association Division for Public Education, everybody at the Sacramento Federal Judicial Library and Learning Center Foundation, also my colleagues at the James B. McClatchy Foundation board who worked so hard on behalf of these kinds of projects. And again, this conversation continues to evolve, but really appreciate your time today, Adam.
It was great fun.
Good stuff. Thanks, everyone.